and domestic violence proceedings. So during one of our conversation, I realized that the amount of insights and knowledge Sandeep has is unparalleled. And today, what we are going to discuss with Sandeep is the things he has realized in his practice, which are the common mistakes that most advocates do during domestic violence proceedings. So, yeah, first of all, thank you, Sandeep, for taking time out for us and sharing your knowledge. And now I'd request you to introduce yourself briefly for our audience.
Yes, first of all, thanks a lot for inviting me here, and I would like to thank from the bottom of my heart 𝘆𝗵𝘂, online education platform in the field exclusively in the field of law, and I have been greatly benefited by taking the 𝘆𝗵𝘂 Master Access program, and it is showing in my day-to-day practice. I've been gaining tremendous amount of knowledge, which is helping me along with my experience that I have gathered during my practice as an advocate in the field of civil and criminal proceedings both. So
Okay,
that's
that's
about it.
great.
I thought it would be a great idea to share it with my brother advocates, brother and sister advocates, and public at large, so that they can take advantage of that.
All right. So, Sandeep, I just wanted you to share a brief about your experience with domestic violence proceedings, how many cases you have handled, and how long have you been practicing it? Start with that.
Right. See, before I started practicing law, I was practicing insurance, banking, and finance as a freelance consultant. And I have
Mm,
got pretty good number of years of experience in the field of insurance, banking, and finance, more than 25 years. And later on, I switched over to the field of law. And then
mhm,
I found law practice more interesting than my insurance, banking, and finance, because in insurance, banking, and finance it was a non-litigation work, but in
mhm.
when I switched over to the practicing side, I found it very challenging and interesting, because to prove a person innocent is a hell of a task. It's a very difficult task. So I took it, lapped up the opportunity with both my hands, and then I started off with it. Till now, I handle more than 100 cases. Okay, but I would like to share my fundamental principle of law here is any law for that matter, whether civil or criminal, doesn't matter. Though we are talking today about domestic violence, I stick to the fundamental basics in my practice in domestic violence. So to begin with, suppose if being an advocate, I'm not supposed to discriminate between male and female. Anybody can come to me. A woman who is a victim of a domestic violence can come to me. Then I am supposed to represent her. A man who's been falsely implicated in a domestic violence case comes to me. I'm supposed to represent him as well. Okay, but what
Absolutely.
I do is, the moment any case comes to me, okay, then I see whether there is a case made out, prima facie case made out or not. Normally they say that prima facie thing and everything is taken care by the court. As advocates, no. As per Advocates Act 1961, every advocate's first duty is towards the court. He is an officer of the court, so his first duty is towards the court, not towards his client. His duty towards the client is secondary. Okay, so when any client comes to me, I see whether the case is made out. If a woman comes to me and if she alleges that my family members have caused domestic violence against me, and then I look into the fact of the matter, and then I proceed accordingly. And there are certain basic fundamental things which one needs to see, is that after you have seen, okay, domestic violence has been caused, let us assume, then what is the next part? Okay, now there are many sections, many rules of domestic violence. The domestic violence has been divided into two parts. Domestic Violence Act 2002, I'm saying domestic violence, but the full of the title of the act is Prevention of Women from Domestic Violence Act 2002. And then there are domestic violence rules as well, 2005, I'm sorry, Prevention of Women from Domestic Violence Act 2005, read with Domestic Violence Rules 2006. So when any advocate is representing his or her client in the court, they are supposed to read both the parts of the act together. They are not supposed to read only the act part and leave aside the rule part. They must compulsorily read both, and then apply the law and domestic violence rules accordingly. This is very important, which I have seen during my practice. I've been seeing, majority of the time we forget about the rules part. We rely only on the act. Plus, we do not look into the fundamental basics which we are taught in our law school. That is whether the court has got the jurisdiction, okay, whether the case is made out, whether the person who is filing the case is making out a case or not, whether the case is maintainable, whether there is any cause of action. All these things we forget. This is very important. First, we should see whether these things are satisfied or not in the case, and then we should proceed further. That is about the beginning of the case.
Okay.
Go ahead.
So that's actually great to hear, because it's very rare. I have been practicing in last 3 years. It's very rare that I see lawyers applying that filter themselves, whether the case is maintainable or not. Most of the time, I've seen that people who are practicing initially, and especially with domestic violence, I've seen that it's generally first and foremost advised by all lawyers that if nothing else, let's go ahead and file a domestic violence case. It would be easier and helpful in getting divorce. And without understanding the prospects and without understanding the necessary requirements. So what is something that you have felt which is very peculiar in your experience with domestic violence proceedings? The number of cases and the kind of cases that you have come across.
Yeah. Peculiarity, what I have observed across all the courts, I'll be very honest with you. I have seen cases, I have been predominantly practicing in Mumbai, Maharashtra. Okay. I have attended many district court cases personally. Mumbai, Thane and Navi Mumbai. These three are districts, located close by. Apart from this, I had been to Delhi, I had been to Karnataka, I had been to Gujarat. All these places I have seen. Rampant either misuse or wrong practice.
Yeah.
Rampant misuse or wrong practice in domestic violence. See, if a particular woman comes to you, see, Domestic Violence Act has been enacted to support or to cut down the domestic violence that is being caused to the woman in a domestic relationship. It's a generalized act to protect the woman in general. But in practice, what happens in the courts is the protection is given only to the daughter-in-law. That is completely wrong. See, I being a man, I have my mother, I have my sister, I have my granny, I have my wife, I have my daughter. All are women. So, Domestic Violence Act doesn't say protection of daughter-in-law from the domestic violence. It says domestic protection of women from domestic violence. So, when a woman comes to me for protection against the domestic violence, I should see who's that woman. And in many of the domestic violence cases I have seen, my sisters, my granny, my aunties, who have never ever stayed with me in a domestic relationship in my house, even they have been arraigned as parties to the domestic violence. This is completely wrong. So that means what we are doing as advocates, by not looking into these factors, we are completely defeating the very purpose of enacting domestic violence. Multiple cases, I'm telling you, multiple cases. I'm just giving you an example. I mean, nothing personal or anything. Now, my sister is married and staying separately from me and my house for the last 15 years. All right. There could have been a conversation between I'm just giving an example. This is not a real life situation. All right. There could have been a conversation between my sister and my wife. Sometimes once in a while or once in a occasional, occasions like a festival time or something like that. So citing that reason, I have seen people make sister's husband, sister's grown-up children, everybody as parties in the domestic violence case. That is not done. It is completely illegal. And I have seen in the other side, advocates don't challenge this right on the first date. And one more thing here, I would like to bring it to the notice of all my brother and sister advocates and other participants, that you should take very big objection right on the first day of the domestic violence case with the judges. Because many times I have heard judges saying, no, that will decide later. Nothing of that kind. Law has to be abided by each and everybody, right from the first citizen, that is the President of India, till the every other citizen in our country. Nobody is exempted from law. So why do we listen to the judge when he or she says that no, we will look it at the time of main trial? No. If a person cannot be made a party to a particular domestic violence proceeding, it cannot be made. So we don't raise these questions at the beginning, and thereby causing a lot of inconvenience to the other parties to the domestic violence who are actually not parties. And there have been many landmark judgments, all right, which have clearly stated that any party to the domestic violence can be made a party only if such party has lived in a domestic relationship with the aggrieved person. Now, every woman who has been subjected to domestic violence, she is called as an aggrieved person, okay, or aggrieved woman for that matter. There is no what you call discrimination. It is a general word, general term, aggrieved woman, right? So if then to make anybody a party, that person whom you are making a party should have lived in a domestic relationship in the domestic household. If that person has not lived, then you cannot make them a party. But rampant, I'm telling you, out of 199.99% of the time, all those parties who are nowhere connected with this case are made parties. So this is the place and time where we as advocates must raise an objection right on the first day, first appearance in the court. This is my observation.
Yeah. So Sandeep, on the basis of that, that's a very important observation, something I have also realized this. But what I have noticed primarily in these cases is that if a client comes to me, because if a woman comes to me, say for filing a divorce case, generally the most common thing is that all the lawyers advise them that make all the family members who are living, not living, incidental, because it's easier as a leverage situation for negotiation later. First thing. And second thing, the problem that happens when as a lawyer I am opposing adding all the family members is that a lot of time their Aadhaar card, their details, and they have stayed for say a brief period of time. Say my mother visits here for a week, and 3 months later, if my wife is filing a domestic violence case, making my mother a party. So how does law view that situation?
See, this is what I have just now. I have said the same thing. Just because my mother has visited my household and lived for a week or 10 days, that doesn't mean that she has lived in a domestic relationship. See, domestic relationship has been defined in the Domestic Violence Act. It says if they have been lived for a longer period together in a domestic household, just living for a week, my mother or even my sister, if she is married, she comes from her mother-in-law's place or parent-in-law's place during, let us say, kids' summer vacation. She stays for a month and goes back. Does it mean that she's in a domestic relationship? Not at all. Domestic relationship can be established by a few documents. Okay, ration card, Aadhaar card, bank statement, all right, voting card. Because normally what happens when we say that a person has been living in a domestic relationship for a very long period of time, or even say a couple of years, normally people would take out documents relating to these situations like bank, election ID card, what do you call it, gas connection, electricity connection. They take out some documents, okay, even for opening a bank account. So these would at least prove prima facie whether they have lived in a relationship or not. So nobody raises an objection. This is the biggest problem. We as advocates should raise the objection. Now I had a case from which was referred to me by one of my good advocate friend. The client is living in Gujarat. All right. Now in that particular domestic violence case, domestic violence case has been filed in 𝗵𝗶𝗃, Kharghar. Okay. They have lived in a domestic relationship in Gujarat. Now just look at the irony of this case. This is a case which I am handling currently. Okay. Now, as per Domestic Violence Act, Section 12, subsection 1, okay, read with Domestic Violence Act, Section 9, Domestic Violence Rules 4, 5, 6, 9, and 10. DIR report is mandatory. Some courts have said DIR report is not mandatory. I don't buy that argument at all. When this section and these many rules of DV says DIR is mandatory, then how come the court say it is not mandatory? Because DIR is the very basis of domestic violence case. It gives a complete detailed account of domestic violence caused to the woman. If I do not know how the domestic violence has been caused to the woman, how will I get relief to her? The entire case has been enacted to give relief to the woman who's been subject to domestic violence. If we do not have a domestic incident report, how will we get her relief? First thing. Second, now in a criminal proceeding, see, Domestic Violence Act is the entire proceeding followed in a Domestic Violence Act is as per CRPC, Criminal Procedure Code. Okay. Now in Domestic Violence Act, there is punishment in only one section 31. That is violation of protection orders. Meaning, if a particular woman has been given protection by the magistrate court or the court taking cognizance, okay, there are certain areas in our country wherein even the family court has been given jurisdiction of the domestic violence case, wherein there is no magistrate court nearby. So in such cases, any court can order that a protection must be given to the woman, aggrieved person. Okay. After giving her the protection, if husband breaches that domestic violence order, protection order, then he would be arrested and put behind bars. And maximum punishment prescribed is 1 year. Okay. So that means this case, all the entire domestic proceedings comes under a summary proceedings kind of a case, which is mentioned in CRPC. Okay. So if the CRPC has been mentioned, summary proceeding has been mentioned, then how do we assess whether the domestic violence has taken place, where it has taken place, and what were the domestic incidences that has caused violence to the woman? So all these things can be ascertained only with the help of domestic incident report, DIR report. But 99% of the cases, nobody files DIR report in support of women. Then how will they get justice to the woman? Any advocate for that matter. Even I have filed 2-3 cases and I have got all the relief to my client, woman. I cannot name them, but I have got residence order, I've got child custody, I've got maintenance, everything, but only with the help of domestic incident report. Now let us take the case of that Gujarat case. Okay, now that he's a doctor, they lived in Gujarat. Okay, after the marriage, during the marriage, his aunties, his granny, who were living 500, 600, 700 kilometers away from their household, they visited the marriage. They took part in the marriage. Okay. After taking part in the marriage, they disposed of. They went away, and something went wrong with this husband and wife, and then she filed domestic violence case here in Kharghar, Navi Mumbai. Okay. Now, Domestic Violence Act Section 9, read with Domestic Violence Rule 4, 5, 6, 9, and 10. It repeatedly says one thing, that domestic incident report has to be filed by the protection officer having jurisdiction in the local area where the aggrieved person resided. What does it mean? The protection officer should file a domestic incident report who is having jurisdiction in his area. Means if the woman has lived in Gujarat, then the protection officer should file report who's having jurisdiction in Gujarat. But in this particular case, can you imagine? Protection officer living in Navi Mumbai has filed DI report.
Okay.
In spite, but see, I'm very clear here. It clearly says, Domestic Act clearly says protection officer having jurisdiction in local area, meaning it is a fundamentally settled principle of law in Criminal Procedure Code that any criminal case, if it takes place, any criminal offense takes place, only the investigating officer having jurisdiction in the area can investigate. This is something similar in Domestic Violence Act, protection officer. But here they have filed, I mean, the protection officer living in Navi Mumbai area has filed a domestic incident report, and that too not verified, no affidavit. There is a compulsion of affidavit if the domestic incident report has been filed. It is in form 1, 2, 3 of domestic violence rules. It is mentioned, prescription is given, form 1, form 2, form 3. But it has not been filed. I challenge the very institution of the domestic violence case right on the first day. It is going on, dragging on. No orders has been given. So my concern is what? If the woman is really needy, if the domestic violence has taken place, then why the advocate representing the woman has not followed these rules? That is the question. So that is about it. You tell me what else.
Yeah, so that was very interesting. First, I think we all understood from what you have said right now the importance of domestic incidents report and importance of following the procedural thing. As an accused, you, Sandeep, I think your
Yeah.
point is,
Yes.
yeah,
Yes. Yes.
yeah. So what I have understood from this is that this is very important as a lawyer, uh, even for the victim or for the accused. For in fact, even after, if I am a lawyer for the accused, I would get a lot of points on why certain procedural aspects have not been followed in domestic incident report.
Exactly.
Yeah. Now, I think Priyanka has a question. We'll just
Okay.
read out. Domestic incident report is ideally filed upon an examination of the aggrieved person only. In that case, it is only on the basis of the version of the complainant. I don't understand the jurisdiction of the investigating officer in this case.
Uh, Fine. Priyanka, you understand one thing here. There is no IO in the domestic violence case. It is always a protection officer. Okay. He has been appointed under Section 9 of Domestic Violence Act. Okay. So if why DR report is mandatory. By the way, I would like to make a special mention of one gentleman here. Okay. Who brought it to my notice? See, this is what I learned from, not only from my advocate brothers and sisters, I learned from the victims, I learned from my friends also. There is one Mr. 𝗵𝗃𝗃. Okay, he's from Hyderabad. I'm taking his name because he's a thorough gentleman. Okay, he told me, he brought to my notice that why domestic incident report is important. Okay, now in Domestic Violence Act, there are many reliefs asked by the aggrieved woman. Okay, protection orders, residence orders, okay, financial orders or monetary relief, okay, interim maintenance orders. All these reliefs are asked, including medical help. Okay, if the woman has been subjected to violence in which she's got injured, then she would require medical help as well. Okay, now if DR report is not there, okay, and if she alleges all these things, how will we make sure that she gets medical assistance, medical support? Without a DIR report, it is not possible, because in majority of the cases in Domestic Violence Act, many NGOs or voluntary service organizations have been roped in to assist the aggrieved woman. Okay, to help those, to make possible for those organizations to help the aggrieved woman, domestic incident report is necessary. Without that, help cannot be extended. And I have seen in the courts, when I raised this question, that there is no such prayer made, or there is no such DIR report which has been mandated in the law. I am not saying it is important because I am saying it has been mandated in the act itself. If we read the act thoroughly, on many occasions it has been given. So if we cannot sideline the importance of DIR report, domestic incident report is mandatory. If at all a woman is in dire need of help, support, medical help, everything, protection orders, then the same thing can be provided by the protection officer's report. And there is a provision in Domestic Violence Act which says that the entire proceeding should get over in 60 days. If I am an advocate representing a woman who's been aggrieved, who's been subjected to domestic violence, then on the very first day after sending the notice, within next 2-3 days, I'll make sure that notice has been delivered and the case is taken on board, because it is a question of protection of women. So that, Priyanka, I believe I answered your question. If you have any other question, you can again post it on the chat. No problem.
So I think, Sandeep, taking from that, what Priyanka meant was that she understands that DIR is mandatory and all, but since it is based only on the examination of the aggrieved person, she wanted clarification that how the jurisdiction will play out, because at the end of the day,
Okay.
when DIR is being produced, it has to be based on the basis of the aggrieved person.
Right. See, now as per Domestic Violence Act, it has given leeway, or it has given the freedom to the aggrieved woman to go and file case anywhere across the country. irrespective of her place of residence where she was living with her in-laws, parent-in-laws or husband. But here the question is, after she has filed the case in a particular place where she is currently temporarily residing, the court which has taken cognizance, okay, through the advocate of that woman, should send a request to the court having the jurisdiction in that area wherein domestic violence has taken place to prepare the domestic incident report by that officer based on the inputs given by this this woman will be filing a domestic violence application in the magistrate court. So the magistrate court can send a copy of that entire thing to the protection officer having jurisdiction in the area, and to conduct a home visit of that domestic of that place wherein the domestic violence has taken place, and take the statement of all the in-laws, collect the information like the bank account details, the job details, everything from the in-laws place, and then submit such report to the court over here wherever she has filed the domestic violence application. Then the proceeding will go further. Without knowing anything, you tell me, without knowing anything, can we proceed against a person just on the statement given by one person? No. Because I will tell you one again here. In the wake of giving protection to one woman, we cannot relegate all other women in the family to the gallows. Can we do that? Can we cause injustice to 10 other women in the family in the wake of giving protection to one woman? My concern is every woman should get protection. If she is in need, if she is being subjected to domestic violence, she must get protection. Simple as that. In fact, because of these wrong practices, I am seeing there are many women who deserve protection from the court, who deserve protection from the government agencies, are not getting protection because of the wrong practices followed. As I have said earlier at the beginning of this webinar, I have got relief to many women. I have fought tooth and nail, but on the merits of the case and in sync with the principles of law, provisions of law of domestic violence. Yes, please.
So Sandeep, we'll step back a little. This is my last question on DIR because I really want to cover other topics also. So
Yes.
in DIR, what do you suggest if a DIR is not filed, or if not, then an immediate objection should be taken, and if still the magistrate goes ahead, then what are the remedies as a counsel for the accused you have?
Yes.
If proper procedural aspects are not followed.
Then I would challenge the entire proceedings under certain provisions of CRPC. Okay. Then there is the question of jurisdiction, section 177 of CRPC. All right. Plus there is section 9 of DV Act, under which I will ask the Honorable Court to appoint a protection officer. Okay. Plus Domestic Violence Act proceedings are not excluded from using Evidence Act. All right. See, if I make an allegation against somebody, I should not be given blanket cover or blanket protection just based on my allegation. I'm supposed to prove it down the line, right? So what initial evidences I'm attaching with my allegations, that is also important. If there are no evidences at all, then I will challenge them. In my case, see, I am talking on merits. I am not talking in the air at all. I am absolutely sure, and I do proper practice in any court, in any case. I practice civil, criminal both. Without my clients giving me evidences, if it is not available at that point in time, then so be it, it's okay. We will do some other alternate arrangement. But I make sure that my clients give me all the documents, necessary document required to prove that client's innocence or to get relief to that client. I'm here being very, very neutral. I do not discriminate between anybody. Please, participants, my brother and sister advocates, do not have any wrong feeling about this. I am a neutral advocate. I take up case from anybody. That is not me. My gurus, my law teachers have taught me to be neutral. As an advocate, I'm a neutral person. Anybody comes to me with a case, I will take it. But what I'm insisting over here is, please follow the rule so that you can get justice to your client. Now, there is one question about interim maintenance. Have you gone through, Yash? Somebody has asked, because that
Yeah, yeah. So I was going to come to that later. I wanted
right.
to structure in
Yeah, please go ahead,
another way.
yes, sure.
So yeah. So we have spoken about DIR. Now I want to come back to very basic one thing. That is a question that is asked most common. Who can file domestic violence? Very basic question, lot of judgments, lot of clarity. But
Right.
today, can mother-in-law by itself file a domestic violence complaint against the daughter-in-law? We know the jurisprudence, but I want to understand your experience with cases where the complainant is not the daughter-in-law, but some other person in the family, and how courts have viewed it.
Right. See, the very title of the act, Prevention of Women from Domestic Violence Act. All right. This is sufficient enough for we advocates to understand. It is the protection of women. So there is no discrimination in the law. Okay. And then there is one definition given in the Domestic Violence Act about aggrieved person. Now, aggrieved person definition says any woman who is living in a domestic relationship in a household, whether shared household, or ownership household, but living in a domestic relationship. These two words and aggrieved person, these two words are very important. So if a mother gets aggrieved by the wrongful behavior of son, or atrocious behavior of the son or daughter-in-law, even daughter, mother can file against daughter-in-law and daughter also.
Yeah,
Similarly,
because against male members, the law is pretty settled. We have seen those happening. But what if one female member files it against another female member, say
yes,
mother-in-law filing against daughter-in-law or their daughter?
yes. See, these things have already happened. To be very honest, I am handling one case in Vikhroli, Mumbai court. All right. Their mother has filed case against daughter-in-law and son
Okay.
for not evicting her from her ancestral house. And court has passed restraining order. So there are instances, but the number of people filing, domestic violence cases on behalf
Mhm.
of mother, grandmother, sister-in-law are very rare, very less in number. It is majorly daughter-in-laws who are filing. But that doesn't mean that Domestic Violence Act gives protection only to daughter-in-law. It gives protection to all the women in the family, starting from mother, daughter, sister, mother-in-law, granny, everybody, all the women in the family, they get protection under Domestic Violence Act. Anybody can file. And there is no such bar, or there is no express bar in the law, to be very honest. So anybody can file.
Okay, great, great. So, and you have also seen from your experience that it's not very difficult if we have appreciable evidences.
Exactly.
Establish that. We just have to
Absolutely.
establish domestic relationship between
Right.
the two.
Right.
So great. Now, second question to this would be, when, as a lawyer, because since most of our audience today is lawyers, when we are drafting reliefs or when we are doing the drafting part in a domestic violence complaint,
Right.
what you must have gone through a lot of complaints of other lawyers as well over a
Yes,
period
yes.
of time. Over a period of time, you have also seen something. You have improved this thing. So, what are your insights when drafting a complaint and especially reliefs while filing the DVA proceedings?
Okay. See, I will speak from both the sides. First, I will speak how to file a domestic, violence application. Okay, DV application in the court on behalf of a aggrieved woman. Okay. See, you will have to narrate the entire incident in a chronological order, right from the day one, when the marriage, how the domestic relationship was made by way of marriage, where the woman resided in the household, whether the house belonged to parents, husband, anybody, that will have to be arranged. Okay, these things. And then when the skirmishes between husband and wife, or in-laws and the daughter-in-law, started happening, so she will have to give a detailed account of all these incidences, right from her marriage till the time she has left the household. There are cases wherein a woman have filed cases while they are living in the household. They have not been evicted, or they have been not been thrown out. She has filed a DV application to protect her from forcefully evicting her from her matrimonial house. The word used here is matrimonial house.
Yeah, correct.
So you will have to go in a chronological fashion, and as you go, you whatever evidences you can attach. For example, if the woman has been subjected to physical violence, then she can always, if she has been to a doctor, or if she couldn't go to the doctor, she can take out photographs of her injured body parts. If she has been scalded, burnt, with the cigarette butt. There have been incidences like this, and I completely shun this inhuman activities. So she can produce these things as a evidence of domestic violence which has been caused to her. So attach all these things with the application and submit it to the magistrate. But along with that, DI report is compulsory. If she is not aware, then her advocate should remind her that we should apply, attach a domestic incident report. That's very important. And domestic incident report can be prepared by a protection officer, and his signature is compulsory on that. Without his signature, DI report is invalid. It is mentioned in the DV Act and DV rules.
Okay, Sandeep. So that was about the filing.
Yes.
Yeah. So after that, should we start taking questions now?
Yeah, no problem. I think there was somebody who was asking me about interim, maintenance.
Yeah. So you want to take that up once? Because we have
Yes.
lot of questions now.
Yeah, no problem. We can take one by one quickly. I'll go through it.
Yeah.
See,
So
interim maintenance. This is, I have seen people fighting on interim maintenance for years together, 3, 4, 5 years. Okay, without any relief. If any person has to get interim relief, I'm talking from the woman's perspective. Okay, if she has to get interim relief by way of maintenance, there are two reliefs given. One is residence order. If she's been evicted from the matrimonial house, then she can pray for residence order. And if she has not been maintained, then she can ask for maintenance for maintaining herself. Now, these two things are dependent on a few factors. Okay. Now, I would like to make one thing very clear here. Domestic violence rules, rule number 6, sub rule number 5 is very clear. Interim maintenance under Domestic Violence Act is granted as per section 125 CRPC. So we will have to read 125 CRPC compulsorily. Understand, see, 125 CRPC says what? That if a husband has neglected to take care or maintain his wife who is not able to maintain herself, if a husband has refused to maintain his wife who is not able to maintain herself, and third, if the wife has refused to come back to the matrimonial household without any reasonable cause or reason, and fourth, if a wife has left the matrimonial house and she is living in adultery with some other person, then she is not entitled for maintenance. So this 125 CRPC is very, very crucial for deciding the maintenance case under Domestic Violence Act. But very few people look into this particular aspect. If you look into it, then 100% you can get relief to your client. So section 23 talks about interim maintenance. What I do, I keep all the facts before the court. I say, if now a few cases I have represented women, okay, and I have kept everything in front of the court. If a woman is married, the set of rules are different. If woman is unmarried, set of rules are different. If a woman is married and if she's got children, then court becomes all the more supportive of the woman. Why? Because the man may not maintain his wife, but what about children? For no fault of theirs, he cannot shun from his responsibility to take care of women and the children. It's very important. So if men come to me, who are married and having children, that I don't want to pay and all, I tell them categorically that don't be under a wrong impression. You have children. Children's are your responsibility. So you will have to pay maintenance to your children. And if your wife is not earning, she's a housewife, you'll have to pay maintenance to her. That's very clear. In fact, in many of my cases, you won't believe, I have asked my clients who are husbands to open a joint bank account in the name of himself and the children and start depositing money even before appearing in the court for the first time. And they listen to me. And I tell them categorically, boss, this is your responsibility. You have come to me to avoid paying maintenance, then sorry, I'm not for it. I've got plenty of clients, no problem at all. So I make them understand. If there is something wrong has happened or some fraud has taken place with you, I am there to protect.
Hello.
mean that you have started paying money to your wife. Hello?
Yes, and there was some
Hello?
disturbance. There was some
Okay, now
disturbance.
it's okay?
Yeah,
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 now
now it.
it's okay? Okay, great.
Can you just repeat the last 2 minutes? We
Yes.
lost it.
Yeah, surely, surely. See, what I'm saying is, it is the duty of the husband to take care of his wife and children. Okay, whether children or not, it is the duty of the husband to take care of his wife. Now, this principle has been settled across all religions. Okay, there is no religious discrimination. Hindu, Muslim, Christian, Sikh, everybody is duty bound. Husband is duty bound to take care of his wife who is not able to maintain herself. That is the point here. Huh? Who is not able to maintain herself. If wife is working, she is earning money, she is taking care of herself, then court may not grant maintenance to her offhand. Okay, so this is very important. 125 CRPC is most important section in domestic violence because domestic violence is governed by CRPC, Civil
Yeah,
Procedure,
so
Criminal Procedure Code.
my
Sorry?
next question was
Yeah.
that only, Sandeep, that this
Yeah.
is a very common confusion and there are a lot of judgments also on this.
Mm-hmm.
That since we have similar relief in 125 CRPC, Hindu Marriage Act, and Domestic Violence Act, how do we reconcile? Are these coexistent or are they in alternative? And can if we do, I think we have lost you again. Right?
Okay, see now. Okay, can you hear me now?
Yeah, now
Hello?
I can hear you. So my question was twofold.
Yeah,
One is
I heard. Yeah,
you heard,
I heard.
right?
Yeah, you have said about 125 CRPC and domestic violence maintenance and other
Yeah,
maintenance. Like
yeah.
many
Are
people
they
find,
coexistence? And if I am denied relief on one of these, can I ask for relief under the other one? These are the two major questions that I have.
right. See, Domestic Violence Act Section 13 says if a woman has got any maintenance in any other proceedings, okay,
Mm-hmm.
maybe 125 CRPC, or some women have claimed maintenance under Section 24 of Hindu Marriage Act, or guardian this one Hindu Minority and Maintenance Act. There are many acts. Okay, so if they have already got maintenance there, then they are supposed to declare it to the DV court. First thing.
Mm-hmm.
Secondly, if there are two courts who have passed maintenance, the higher one would be upheld. Higher the maintenance order which prescribes higher maintenance would be granted. Both the orders normally would not be granted. But to be very honest with you, I have seen many cases wherein the husband is paying two maintenances at a time under 125 CRPC and under Domestic Violence Act also. But but it is a wrong proposition because under domestic violence rule 6 sub rule number 5 they have clearly mentioned that the before the granting of maintenance under DV Act should be in sync or as per section 125 CRPC. So that means what? Once you have already considered 125 CRPC for maintenance in DV Act, you cannot claim again maintenance under 125 CRPC. This is my understanding and interpretation of law. You tell me. When in DV Act it has been clearly said while granting interim maintenance or maintenance for that matter, you should take 125 CRPC into consideration. So the moment you say 125 CRPC into consideration, a lot of factors come into picture. Husband's ability to earn or the amount of earnings he is making, his liabilities. If he's got dependent parents, then he is duty bound to maintain his parents as well. Maintenance and welfare of parents and senior citizen act 2007 act is there. Very few people are aware. So if he pays to his wife, he doesn't pay to his parents, then his parents can go against him in the court for claiming maintenance. So while a court grants maintenance to wife, they have to keep all these things into mind, plus the liabilities of the husband. If husband is having a home loan or any other liability on him through which he is paying money from his salary or from his income, then all those things should be deducted, and out of the balance amount, maintenance should be granted to the wife. And maintenance means what? In Domestic Violence Act and 125 CRPC also it is mentioned. Maintenance means it is a sustenance amount. It is sustenance amount for her to be able to live. That is the main thing here.
Okay. So yeah, a follow-up question to this, because what in my experience has always happened is that parallel proceedings go on. Generally,
Yes.
you do not get the maintenance, say under 125, and DVA parallel proceeding is going on.
Hmm.
So
Hmm.
can you, if you have lost one,
Hmm.
if you lost 125, so
Hmm.
the other party will always use that, saying that they've already lost one case, so this has a necessary bearing on the current maintenance.
Hmm.
So how do
Bearing in
we,
what sense? Bearing, you do you mean to say they will lose it, or they need it? How is it?
they will lose it? Because generally they say that these proceedings have already happened, the evidences have already been let, the court has done the findings, so
Okay.
now why do you want to waste another, you're just forum shopping.
Right. See, yes, I will tell you, I will go back again. All right. Go back meaning, see, I have lost it. That means after losing, what I'll do, I'll go for corrective measure. Even
Mhm.
before I lose my maintenance case, I will prepare so well in advance that I don't lose my maintenance case. That is important. Na? I see courts are here to support the people. I mean, those people who are in need, okay,
Mhm.
courts are here to give them their need, give them protection. And DV Act is very, very powerful. It is majorly in support of women. See, the very
Correct.
purpose of enacting DV Act, if we read the objective of DV Act, it is clearly mentioned. Court will not go against a woman until unless she has done blunders in the court. So if I am representing a woman who is
Mhm.
in desperate need of a residence order, house, and maintenance, I will show it to the court that, my lord, my client is in need.
Mhm.
If this court doesn't grant any relief, she will be on the roads. She will be left in lurch. She will become a destitute person. So this is in my hands to show it to the court. So I will do everything in my capacity to show it to the court that my client is in need. If at all after this I lose my case, then I will have to go to the appeal. And one more thing here. One more thing here. There is no law in India which says that because you have lost in one forum, you will
Yeah.
that will have a negative impact in the other forum.
Absolutely.
This is a complete wrong interpretation.
That
Because
is what I was getting into, that since these are independent proceedings, but still
independent
we have
proceedings.
seen in practice that one will always influence the other.
Yes,
So,
but I will tell you here what happens. What I have observed. I'll share it with you. Now, what
mm,
happens is sometimes in DV proceedings, a certain set of facts have been narrated, stated. Okay, based on those facts and the opposite parties' statements, the woman has lost the maintenance. Okay, now after this, she goes to another forum. After DV, she
mm,
goes to 125 CRPC, or let us say Hindu Marriage Act Section 24 for asking for maintenance. When she goes over there, she narrates different set of incidences. She narrates different facts which she has never said anything about in her DV proceedings. Okay. Now here comes the question of law. Okay. Evidence Act. Any document which becomes the property of the court
but,
gets a exhibit number. Okay, so
mm,
that becomes the document of the court. And once that proceeding is over, okay, that once that document has got the exhibit number, okay, that means what, court has taken judicial notice of those documents. Based on that, the verdict has been given and the woman has lost. Now woman goes to another forum and she narrates separate set of incidences or separate set of facts which she has never said in the earlier forum. So as per section 56 and 57 of Indian Evidence Act, these set of documents can be produced as a evidence in the other court. Why? Because it is stated in the Evidence Act. Section
yeah,
56 says, yeah, Section 56 says documents of which the court takes judicial notice of may not be proved. This is Section 56. Now, Section 56 gives a long list of documents of which court must take judicial notice of. So then what will happen if woman has stated two separate set of incidences, two set of facts in two different forums, she will be contradicting her own statement. So it becomes difficult for her to get maintenance in the other forum. Why? Because if the opposite advocate over there brings out these facts, saying that these facts have been accepted by the court in the earlier proceedings and they were rejected, now she is alleging different set of facts. So
correct,
this
correct.
is very important.
Yeah. So
Yes,
Sandeep,
please.
yeah.
Yes.
So now now I'll move to the next question. Another question on our discussion was that can we put domestic help for under Domestic Violence Act?
Domestic help.
Can, yeah. Can the
See,
domestic help be complainant under DV
yes,
proceedings?
Yes, under only one circumstance. If that help resides in that household 24/7, 365 days a year, then she can be, as per my understanding. Because
Okay.
she comes into the domestic relationship straight away.
Hmm.
Because she is living amongst the family members 24/7, 365 days a year, she can file. If I this kind of a case comes to me, I will take it up and I will represent it. If she's been subject, no, listen, if she's been subjected to domestic violence, there could be cases, just to extract money, people must be doing it. I don't see, being a criminal practicing lawyer, I look at things from suspicion point first, and then I make sure that things are okay. They are not, what you call hunky dory. Hello, yes,
Yeah, Sandeep, I'm
yes,
listening.
yeah.
So, last question probably, because I think we are already approaching time. So I would like, the last question is regarding timing of the filing. So in domestic violence case, lot of time question comes of delay in filing the domestic violence complaint.
Hmm.
And
Hmm.
this happens because the woman generally, as we know in our society, the woman will go back to her parents' house.
Hmm.
There will
Hmm.
be a long period of negotiation between the guy and the girl
Hmm.
that
Hmm. Hmm.
things
Hmm.
will improve. So probably a cooling off period of 3 or 4 months is there,
Hmm.
and then a domestic violence complaint is filed by the woman in the court. So
Right.
how does law view that period? What is the best strategy in going before the court and explaining this intervening period?
The delay, right?
What has been your experience regarding that? Because this is probably one of the first thing that I have come across that is problematic, that always happens, that there will always be a period of 5 to 6 months of
Delay.
negotiation.
You are saying that you have come across cases wherein delay has happened for 5 to 6 months. I have seen courts have across India have been very, very generous in accepting domestic violence applications. Courts have accepted domestic violence applications even after 4 years of delay. They have accepted it. Okay, but there is a no, section 468 in CRPC which says
Mm,
that any offense under which punishment prescribed is 1 year. Okay,
mm,
then beyond that 1 year, the such complaint related to such offences cannot be made. Domestic violence falls under that category of 1 year delay.
yeah.
Okay, but many places I have seen people filing domestic violence cases 4 years after the domestic
Yeah.
violence has taken place. But then what will happen if a person delays so much? There will be no teeth left in the case. If the opposite advocate is very strong and he's very particular about the provisions of law, then I don't think so woman will get relief, because she will have to show it to the court. Why did she take 4 years to complain? Because see, in domestic violence act, provision is there, you can file anywhere. You don't even need to go back to your mother's house or anywhere. You go anywhere, file it there, and all that you need to do is just give a call to protection officer, and he or she will come to your place, note your DR report, make your DR report and file. Filing is very easy through protection officer. Form
Yeah.
1, 2, 3, protection officer will fill. He or she will fill affidavit on behalf of the aggrieved woman, and then he can file it. He will file the application to the magistrate, and magistrate will issue summons. This is very easy, but then they are not doing it.
Correct. So, yeah. So thank you so much. I think that provides a lot of clarity.
Yes.
So thank you so much for this informative session. Unfortunately, we could not take all the questions.
Yeah.
Is it something else you would like to elaborate on, or should we
Uh,
close the session?
See, now one advocate Mitesh has said that there are High Court decisions which have said 468 CRPC is not applicable to DV Act. They say DV Act is a continuous act. But see,
Mhm.
I wouldn't. There have been contradictory statements from different High Courts. Okay, there is no uniformity or there is no unison. I mean, Supreme Court has still not come out with any landmark judgment related to
Yeah.
application of 468. But what I say is, if a woman is subjected to domestic violence and if she is in need of maintenance and residence order, okay, place to live, then why should she delay 1 year, 2 year, 3 year, 4 years? That itself will show the intent, right? She
Correct.
should show why she has delayed. If she's in need, then she should approach the police, the protection officer. And nowadays, and all the police stations, if any woman approaches with domestic incidents report or domestic violence report, they direct her to the protection officers, because now across India, all the states have appointed protection officers to give support and assistance to the woman, aggrieved woman. So they should do it. And there is one more question. Sandeep ji, please touch upon how can one reclaim the maintenance already given once the case is either dismissed or proved irrelevant. Now, I don't know whether this is from the last, please touch upon one can reclaim the maintenance. Okay. So maintenance, I think this is my good friend, Advocate Lal Tejwani. He is a very good friend of mine. So he has asked this question. I would like to answer it. See, now to reclaim the maintenance, if the maintenance has been dismissed, then we will have to give the real life scenario to the court. What the woman is doing, what's her education qualification, what is the condition she is living currently with her parents' house or any shelter home or anywhere, that we will have to bring. Plus, we will have to also show the position of the husband, what he is doing, what are his properties, whether he is owning a property or not, and what he is doing these acts deliberately. All these things we'll have to show. And once we show, there is no reason why we cannot claim back the maintenance. And I have seen certain cases wherein after the divorce, woman has claimed maintenance under 125 CRPC and it has been granted because she was living in a terrible condition, and court said no, you will have to pay maintenance at least for her sustenance money. So it was granted. So that is possible. Even in DV it is possible.
All right.
I think yes, I will post my email address if anybody wants to get in touch.
I was going to say that only, that if anybody wants to reach out, please can you give your email ID and LinkedIn account also, right? People can reach you out on LinkedIn, right?
Yes, sure.
So guys, if unfortunately we are really sorry we could not take all of your questions, but I'm pretty sure that Sandeep, being exceptionally helpful as he is, he would readily reply to all your questions on LinkedIn. Please reach out to him. Sandeep, can you speak your email ID also?
Yes, it is ADV as in advocate, ADV Shergar, SHEREGAR, ADV Shergar @gmail.com. That is my email ID. So yes, if we can take a couple of questions, we still have been left with 3 minutes. Okay, if you want to take any questions, you unmute the participant or something, you can do that.
No, if you can take any of the questions that are there on the chat, which we have.
Okay, I will just. Okay, can we get court order to set up a CCTV inside house to prove no DV has taken place? Okay, see, in this regard, court will normally not give permission to set up CCTV because husband and wife relationship, they consider as a private matter. But I think barring the bedroom, you can still install CCTV in the common areas like kitchen, hall, all those areas, balcony, all those areas, leaving aside the washroom and bathroom, toilet and bedrooms. These areas apart, you can definitely install CCTV cameras. I don't think so there should be any resistance to it. If at all there is any, then you can bring it before the court. How will I prove my innocence? There have been incidences wherein people are targeting. So you can definitely put that in. Until unless you get an adverse court order, you can go ahead with it. But avoid putting anything in the bedroom and toilet, bathroom. That's very important. I mean, privacy will be breached. Okay, any other question? Let me just see. Some role of protection officer as accused or complainant, what should be kept in mind while dealing with protection officer? Okay. Kunal Kaushik has asked, kindly please throw some light on role of protection officer. Friends, see, protection officer is a public servant defined under DV Act. Okay, he is just like a investigating officer. Only difference is he doesn't have the power to arrest anybody. Okay, barring that, he's got all the powers. Okay, he is an officer of the court. You can directly approach the protection officer, or you can approach the protection officer of the officer through the court. Now, I would like to state one very interesting incident here. Yes, in one of my cases, wife. Hello.
Yeah, I'm listening.
Yeah, in one of my high-profile case, okay, wherein husband is a manager with the multinational bank. Not manager, I'm sorry, director with the multinational bank. Wife is a chartered accountant with the private bank. So very good profile. She filed domestic violence case against my client. I was representing the husband. So it was devoid of DIR report. Okay. And
Mhm.
she concealed it from the court that she is earning 1 lakh rupees per month. She also concealed it from the court that she is living in an ancestral house in which she's got a share worth 5 crore. Okay. So now when we went ahead in the case, it
Mhm.
happened in Mumbai and the jurisdiction was there, so I didn't go to challenge them. It was well within the limitation period and everything. And as I proceeded in the court, they started insisting very heavily on the interim maintenance. And I resisted it because my client told me all the profile about the wife. All right. So now she lied everywhere. She even filed an affidavit in which she did not agree or she did not state anything about her salary, about her job, nothing. And she claimed 1 lakh rupees maintenance. I'm sorry, and plus compensation amount, financial compensation amount worth 50 lakh rupees, and residence order equivalent to a house where she was living earlier, or 70,000 rupees rent in lieu. All these things she asked. I resisted it, and then I moved an application under section 9 and DV rule number 4, 5, 6, 9 and 10, read with section 12 subsection 1 of DV Act for appointment of protection officer. And I stated to the court that, my lord, there has been a lot of false statements made by the applicant here in this proceedings. So to verify the details of the case, we must appoint a protection officer who can go to the court of the who can go to the household, okay, matrimonial household, and inquire everything. So he did that inquiry and everything, and then he submitted his report. Now through that report, everything has come out because he went to the house of the wife. He took separate statement from her, just like investigating officers in criminal case. What do? They go to first, they if it is a cognizable offense, they arrest the accused. Okay, and when they file FIR, they take all the statement from the complainant and the witnesses. So same thing protection officer did. Now this case has been poised very nicely. All her falsehoods have come out because protection officer has revealed everything. So this is the methodology by which you can bring out the falsehood before the court. So this is possible. And one more question was there: how to reclaim the maintenance? If there was any maintenance granted earlier and the husband has not paid the maintenance, you people always can file a recovery proceedings or execution proceedings for recovery of the arrears of maintenance up to 1 year. Beyond 1 year, you cannot claim that maintenance. Meaning, if the husband has not paid maintenance for the last 2 years, starting from today, okay, going back up to 2 years, you cannot claim for 2 years. You can claim for 1 year. So go for execution proceeding in the same court where the proceedings are happening. So that's about another question's answer. And now, okay, there is, can father-in-law Vidisha Day, can father-in-law ask a daughter-in-law not to stay at his home for a few days? What if she gets into her matrimonial house for staying few months and abused badly? Does that invoke DV? Abused badly. Okay. Vidisha, I would like to be very clear and frank and honest here. See, multiple times it has been upheld by many high courts and especially landmark judgment case delivered by the Supreme Court of India, 𝗵𝗏 versus 𝗵𝗏. It has been clearly established that daughter-in-law cannot stake any claim in the house self-owned by the father or the father-in-law or the mother-in-law. She cannot even forcibly get inside the house of parent-in-laws. That is completely no. If you try to do that, then you may be in problem. So don't do that. That is not allowed. If it is your husband's house, you have got 50% right on his property. You can get inside any time. So that is the settled law. 𝗵𝗏 versus 𝗵𝗏 is the landmark judgment. It's very, very clear. So you can always read through it and then you can search for alternative remedy. Okay, now Priyanka Gorawat has asked one question. There is a concept of affidavit of income and expenditure in Delhi court basis a high court judgment 𝗀𝗵𝗂𝘃𝗁𝗏𝗏 for the information of the respondents. Yeah, this is a very nice judgment given by the Delhi High Court, in which they are asking for the income and expenditure affidavit by both the parties. So this is a clear law, fair law, which has laid down the law that you produce your income affidavit, and if anybody is found lying, then that person will be at the receiving end. If the wife lies about her income and expenditure, she may not be eligible for maintenance, and if the husband lies, then wife will get the maintenance that she has asked for. So that's a very good judgment. 𝗔𝗱𝘃𝗃 versus 𝗵𝗃𝗃. Are directed. Okay. Now 𝗀𝗵𝗁𝗿 has asked one question. What about interim protection asked in main petition? These interim protections are decided at the end of the case or initial level. See, interim protection, when you are saying interim itself, means that it has to be handled initially. It entirely depends on the advocate representing the woman, how he or she has represented the case of the woman seeking interim protection. Now, protection order is always given under section 18 of DV Act. So you should be aware about that. Prepare your case in such a manner that your client, the woman, aggrieved person, must get protection. You show all the wrongdoings done by the in-laws family or the woman. If it is required, ask your client to undergo a medical test, attach the reports, and then submit it to the court and bring it to the notice of the court that there is an imminent threat to the aggrieved person, imminent physical harm or threat to the person, aggrieved person, and court would grant protection orders. Court wouldn't shy, but you have to show it whether there is really an imminent threat. Okay, what is the time frame? Okay, this I think we have handled. Time frame within the period DV has to be filed. Normally, I believe it is 1 year, but people have filed after 4 years also. It has been accepted. Okay, any other question? Okay, is sister-in-law, daughter-in-law staying separate and occasionally? No, this wouldn't amount to DV. This is clear. I mean, courts don't even send them summons. Even if they send them summons, if they don't appear, it's okay. By the way, it's one very important question, information I would like to share with one and all. In domestic violence case, the respondents need not appear before the court until unless specifically summoned by the court. I have seen people rush to the court, but not required. It is clearly written in the law that the advocate for the respondent or advocate for the complainant or the DV applicant can represent the parties to the dispute. So not required. So keep this thing in mind. I have seen people traveling from far-flung areas just to be on time in the court, not required. Until unless court has specifically asked the parties to the proceedings to appear in the court. Otherwise, it is not required. This is not a criminal case. DV is a quasi-criminal case. Rather, it is a civil case. Why they call it quasi? Because the procedure followed in DV case is criminal procedure code. That is the reason it is called as quasi-criminal. So that's about it. Yes, I believe there is not much of a question. So if you can unmute the participants if anybody is interested.
No, I think we have very specific doubts now. We do not have those doubts. I think they can take up with you personally. These are very case specific doubts that we are getting.
Okay. Now there are two questions I would like to take. Very important question. Okay. I just would like to take very nice question. Okay. 𝗃𝗃𝗃. In one of the incident, husband disappeared and not known, and his whereabouts are not known. Subsequently, his parents died. The woman aggrieved is subjected as no one to her help. How to go about it? 𝗃𝗃𝗃, I would like to tell you here. Please find out whether the household belong to the husband's parents or it is an ancestral property. If it is ancestral property or inherited by the father-in-law of the woman, then woman has got a share in the property by way of wife of the husband. Okay, so you can claim immediately. You can put a suit or file DV also to restrain the husband's family from alienating the property or selling of the property. So you have got that, but you cannot ask for maintenance from the in-laws. You can ask for maintenance only from the husband. But alternatively, you can ask the permission from the court to sell off your client's share of the property and make money to sustain or maintain herself. So that is possible. Okay, now there is, in cases where there is no shared household for the applicant with in-laws, what is the relief similar to discharge, meaning early exit from the false proceedings? In this regard, I think Sandeep is the name of the person. I don't see here what's his name. Sandeep, okay. Okay, Sandeep. See, now in case of you can file for discharge, no doubt about it. Discharge comes after the interim application has been granted, and the court the DV application comes to the main proceedings. But you can, if there is no merit in the case, okay, entire case is false, then you can file for dismissal of the case under section 203 of CRPC. Okay, so that you can do. Anything else? Yes.
Um,
I think we are done. All the questions are over.
yes,
Thank you,
I
Shelly
think
madam. I have my colleague also. Her name is Advocate 𝗀𝗵𝘁𝗃, so she is giving me a compliment. Thank you, Shelly madam. Thanks a lot.
yeah, like Shelly said, thank you so much, Sandeep, for dealing with all the questions so ably. I
Yes.
don't think we have had session where somebody has answered all the questions, taken each and small question in such a detailed manner.
We had
I'm
good
happy.
time on hand. That was the
Yeah,
thing. Anyway, even I would like to express my heartfelt gratitude and thanks to all the participants. If I can be of any further help or support to anybody, please feel free to contact me on my email address that I have already stated. Again, I am sharing it over here. You people are free to contact me on my email address. Send me an email. I will definitely try to reply all your emails. Thank you so much and all the very best to all my colleague advocates and your participants.
and taking forward to what Sandeep said, this is one of the things we take utmost pride in 𝘆𝗺𝘃, that we have students who are as diverse and who can add such value. So if any of you want to check in detail, we have a course on criminal litigation where we take Domestic Violence Act as one of the topic, and you will have a lot of value addition in this. So you can contact me on LinkedIn for any questions regarding to the course. And in any question regarding to the session or anything, you can always reach out to either of us. Thank you so much,
So
guys.
thanks,
We will,
Yash. You have been a great host. Thank you so much. Looking forward to conduct more such webinars. Thank you
yes,
so
that's
much.
what I'm going to
Have a
say,
nice
Sandeep,
evening.
that
Yeah,
I'm really looking forward that we will have more such
yeah.
webinars.
Have a nice evening. Bye.
Same to you. Bye, everyone. Thank you so much for being such a patient